All right, so we're diving deep today into something I think a lot of renters in California have at least thought about at some point. It's the Tenant's Guide to Small Claims Court in California.
Yeah, definitely. I mean, as a tenant, you're bound to run into some disagreements with your landlord at some point, right? And
happens to the best of us.
yeah, exactly. And, knowing what your options are is really important. So that's why today we're going to really break down this whole small claims court thing in California. What is it? When does it make sense to use it? How do you actually navigate the process? And the good news is you usually don't need a lawyer for this, which is a huge plus for a lot of folks.
Definitely takes a lot of the stress out of it, right?
Exactly. Yeah, so we've gone through a bunch of different resources, guides, FAQs, all that good stuff, to try to pull out the most important nuggets of information for you guys, so you can really understand what this whole small claims court thing is about.
And why should you care? Well, because whether it's that security deposit that never seemed to make it back to you, or dealing with some pretty bad conditions in your apartment, or really any other issue with your landlord that you just can't seem to resolve, small claims court can be a direct way to try to find a solution.
Yeah, it can be really empowering.
So let's just jump right in. Okay. What is small claims court even meant for when we're talking about these tenant-landlord situations? Like, what kind of stuff are we dealing with here?
Well, the interesting is that small claims court is set up for people to settle disagreements directly without having to go through like a big formal lawsuit. And it's really geared towards claims that involve money, and usually for amounts that are under a certain limit.
Oh, okay. So it's like keeping it kind of smaller scale, simpler to handle.
Exactly. Yeah. And that's what makes it a pretty good option for a lot of tenants, because it's accessible. You don't need a lawyer. You can represent yourself, and it's designed to be relatively straightforward.
So you don't need that like law degree just to understand what's going on.
Right. Exactly.
Okay. So I think a really important thing to figure out first is if your problem even fits into what small claims court can handle. So, like, what are we talking about money-wise? Are there limits? What are the numbers?
Oh, absolutely. That's a key point.
Right.
So for tenants in California, if you're an individual, the current limit you can claim is $12,500.
Okay, that's good to know. $12,500 for an individual.
Yeah, but there's a bit of a catch. If it's a business acting as the tenant, then the limit is actually lower. It's $6,250.
Oh, okay, so a business, it's $6,250 versus $12,500 for individuals. That's an important distinction.
Absolutely. So, before you even think about filing a claim in small claims court, you got to make sure the amount you're trying to get back falls within those limits.
Right, because if it's way over that, you're probably looking at a different kind of process entirely.
Right.
So, okay, so money aside, what are some of the other things about small claims court that make it a good option for tenants who are having problems with their landlords? What are the benefits we're looking at here?
Well, there are actually several things that make it appealing. So first off, as we already touched on, you usually represent yourself in small claims court. Attorneys aren't typically allowed, which keeps the costs down significantly.
Okay, yeah, that's a huge barrier for a lot of people, right? Having to pay for a lawyer.
Exactly. And on top of that, the filing fees themselves are pretty reasonable. They range from about $30 to $75 depending on the amount of your claim.
So $30 to $75, that's manageable.
Right. And another great thing is that if you have a low income dwelling, there's a possibility of getting a fee waiver, so you might not even have to pay that.
Oh, wow. That's really good to know.
Yeah, so it's designed to be accessible.
Absolutely. Okay, what about time? Because I know that dealing with landlord disputes can be incredibly stressful and people just want it to be over,
Absolutely. So another huge advantage is that cases in small claims court are usually resolved pretty quickly. Typically, it takes somewhere between 30 and 70 days after you file the claim, which is way faster than what you might expect in a regular court case.
Wow, yeah, 30 to 70 days. That's not bad at all.
Right.
Okay, so it's potentially faster, it's less expensive. But what happens if you go through that whole hearing process and then you're not happy with the judge's decision? Can you appeal it?
Oh, this is a really crucial point. You need to be aware that the decisions made in small claims court, those judgments are final. Generally, you can't appeal them. So you really want to make sure you're well prepared going into it.
That's really important to know going in.
Yeah, and also keep in mind that even if you win the case and the judge says your landlord owes you money, it's your responsibility to actually collect that money. The court doesn't automatically do it for you.
Oh, that's a really good point to bring up because people might assume the court will handle all of that. Okay, so we have a better idea of what small claims court is and some of the key things that make it unique. Now let's talk about those specific disputes between tenants and landlords in California that often end up in small claims court. What are some of the common scenarios that we're seeing here?
Yeah. So the sources we've looked at point to a few really common situations that come up. One of the biggest ones, and I think this is something a lot of tenants have experienced, is disputes over security deposits.
Oh, yeah.
California, the law is very specific about this. Landlords have to either return your full deposit within 21 days after you move out, or they have to give you an itemized statement explaining any deductions.
21 days, that's all they got.
Right. And, disagreements about those deductions, or even worse, the landlord just doesn't return the deposit at all. Those are incredibly common reasons why tenants go to small claims court.
Yeah, it seems like security deposit issues are like a constant source of tension.
Yeah.
What other kind of issues do tenants often bring to small claims court?
Another big one is what we call habitability. So basically, if your rental unit has problems that make it unsafe or unhealthy to live in, things like mold, serious pest infestations, not having heat or hot water, these are things that a landlord is legally obligated to provide.
Yeah, that's basic stuff. You got to have those things.
Right. It's like the bare minimum. And you can actually seek compensation in small claims court if those basic habitability standards aren't met.
Okay.
And then we also see cases where tenants are trying to get reimbursed for damage to their belongings that was caused by the landlord's negligence.
Oh, so like, for example, a leaky roof that the landlord didn't fix even after you told them about it, and then it damaged your furniture.
Exactly. It's a classic example.
Yeah.
And finally, you have disputes about things like illegal fees that a landlord might try to charge, or retaliatory actions like trying to evict you unfairly after you've stood up for your rights as a tenant.
So basically, if the landlord is doing something shady or trying to get away with something illegal, you might have a case in small claims court. Okay, so let's say someone listening to this thinks, okay, small claims court, this might be the way to go for my situation. What are those must-do steps to actually get the ball rolling and file a claim?
So first and foremost, you need to do a little bit of homework. Make sure small claims court is the right place for your issue. Does it fit within that $12,500 limit for individual tenants? And is it the kind of dispute that small claims court is designed to handle? Once you've checked those boxes, there's a really important step you need to take before you even file any paperwork with the court. You have to send a formal written demand to your landlord.
Oh, so you can't just like march down to the courthouse and file a lawsuit.
Not quite. This formal demand has to be in writing, and it should clearly outline the problem you're having and the amount of money you're asking for. This gives your landlord a chance to resolve the issue before it goes to court. It's like a heads up.
Okay, so it's like an attempt to settle things amicably before going the legal route.
Exactly. Only after you've sent that demand and you haven't gotten a satisfactory response or any response at all, should you move on to actually filing your claim with the court. And that involves filling out the right form, which is called Form SC-100, and it's got a long official name, plaintiff's claim, in order to go to small claims court. You file this form with the small claims court in the county where your rental property is located.
Okay, so got the form, got it filed at the right courthouse. Now what? Does the landlord just magically know they're being sued?
Nope, not quite. This is where the whole serving the defendant part comes in. You, as the person filing the claim, you're responsible for making sure your landlord is officially notified that they're being sued. This has to be done by someone who's at least 18 years old and who's not involved in the case. And they actually have to hand deliver those court papers to your landlord at least 15 days before your court date.
Oh, so it's like physically putting those papers in their hands.
Yeah, and after the landlord has been served, the person who did the serving has to fill out another form called Form SC-104, which is basically proof that the landlord was properly notified. There are a few different ways to do this whole serving thing. Personal delivery certified mail with specific rules, or you can hire a professional process server. But personal service is often the most reliable way to make sure it's done right.
Okay, that makes sense. You want to be extra sure the landlord knows what's going on. So now let's talk about getting ready for that actual hearing. What should a tenant do to make sure they can present their case effectively and, hopefully win their case?
Preparing well is absolutely key to increasing your chances of success. And the most important thing is to gather and organize all your evidence.
Oh, yeah. Evidence is everything.
Exactly. So we're talking about things like photos and videos that clearly show the problems you're having, receipts for any money you've spent because of the issue, copies of all your communication with the landlord, emails, text messages, letters, and of course a copy of your lease agreement.
You want that paper trail.
Exactly. And a good tip is to bring at least 3 copies of each piece of evidence to the hearing, just to be safe. And when you're organizing all this stuff, try to do it in a logical way, like chronologically, so it's easy to follow. And most importantly, make sure you can clearly explain how each piece of evidence backs up your claim. You'll also want to prepare what you're actually going to say to the judge. Practice explaining your case in a clear and concise way, focusing on the key facts. And if there are any specific laws or local ordinances that support your side, be ready to mention those too.
So it's not enough to just show up and be like, this is what my landlord did. You really need to come prepared.
Right. You need to be organized. You get to have your ducks in a row. So when the day of the hearing arrives, make sure you get to the courthouse early, give yourself plenty of time to check in. And then when your case is called, present your case calmly, respectfully, and clearly, and listen carefully to what your landlord has to say.
Okay, so be on time, be polite, present your case. Got it.
And it never hurts to dress professionally too.
Yeah, first impressions matter. Okay, so you've gone through the hearing, and let's say the judge has ruled in your favor. What's next?
All right, so if you win, the court will issue a judgment, which is basically a legal order that says your landlord has to pay you a certain amount of money. But as we mentioned earlier, small claims court judgments are usually final, so there's no going back. So your next move is to send your landlord a formal written demand for payment.
Okay, so another demand letter, but this time you've got the court backing you up.
Exactly.
Yeah.
And if your landlord still refuses to pay, then you'll have to take additional steps to enforce that judgment, which can involve things like garnishing wages or levying bank accounts. And this might mean more paperwork and some additional fees.
So winning the case is a big step, but actually getting the money you're owed sometimes takes a little more effort.
Unfortunately, that's true.
You mentioned earlier how important evidence is. So can you give us some more specific examples of the kind of evidence that's really convincing in these tenant-landlord cases?
Sure. Having strong, well-organized evidence is really the backbone of a successful case. Your lease agreement is always a good starting point because it lays out the terms of your tenancy. But when it comes to things like habitability issues or property damage photos and videos can be really powerful, they give the judge a visual understanding of the problem.
Yeah, a picture is worth 1,000 words.
Exactly. And if you have receipts for any expenses you had to pay out of pocket because your landlord's in action, those are really important too. Like if you had to buy cleaning supplies to deal with mold, or you had to stay in a hotel because your apartment wasn't livable, keep those receipts and save all communication with your landlord, every email, text, letter, everything.
Create that paper trail.
Right, because it shows the timeline. It shows if you notified them of the problem and how they responded or didn't respond. The more specific and dated your evidence is, and the more clearly you can connect it to your claim, the stronger your case will be.
Okay, so basically document everything.
Pretty much.
All right, we've covered a lot of ground here. Just to wrap things up, what are the most important takeaways that a tenant in California should remember if they're considering small claims court?
Okay, so here's the quick rundown. Small claims court in California can be a good option for tenants to resolve disagreements with their landlords without having to hire a lawyer. But there are some key things to remember. The limit for individual tenants is $12,500. You absolutely have to send a formal written demand before you file anything with the court. You need to follow the correct procedures for filing and serving your claim. Gathering and organizing your evidence is super important. You'll be representing yourself in court, and remember, those judgments are final. And if you win, it's up to you to enforce them.
And for those in Orange County, Riverside, San Diego, and Los Angeles, California, dealing with issues like evictions or those premises liability accidents in apartments, you can check out martinezlawcenter.com. So all of this information is really helpful. But here's a thought to consider. Even though small claims court can be a great tool, is there anything tenants can do proactively in their relationship with their landlord from the very beginning to try to prevent these disputes from even happening in the first place?
Oh, that's a fantastic point. I would say one of the most important things is to really carefully read and understand your lease agreement before you sign it. Make sure you know what your rights and responsibilities are.
Yeah, don't just skim through it and sign on the dotted line.
Exactly. And maintaining open communication with your landlord throughout your tenancy can really make a difference. If you let them know about problems as soon as they arise, and you're both communicating clearly and respectfully, it can help to prevent things from escalating to the point where you need to go to court.
Absolutely. So clear communication from the start is key. Hopefully that can prevent a lot of these issues from even happening in the first place. Well, we hope this deep dive has given you some useful information about small claims court in California. And if you're looking for even more in-depth details and resources, the California Court's website has some great self-help guides specifically about small claims court. You can usually find those by just searching online for California Small Claims Court self-help.
Yeah, there's a lot of good information out there to help you navigate this whole process.
Definitely. So do your research, be prepared, and good luck out there, renters.
Yeah, good luck.
Call now 714-442-9741. Thank you.